applied my mind to all circumstances and came to an informed conclusion that immediate action was necessary. I simply wish to motivate briefly the point which the interveners make that, in fact, this prorogation is improper and it should be found to be so by the court. Summarized on one consideration, it is clear that the Prime Minister does not make any reference to the fact that he is obliged to report to the Parliament, because the law is clear. Once he had come across a position where, although in terms of the law His Majesty is obliged to follow his advice, which in fact I would coin it that the word advice used there is but the courtesy, his instruction, let me put it like that. The Constitution has been drafted by the legal draftsman in such a manner that it accommodates a situation where in certain matters of conscience, the king may be in the position to say, well, I know that I'm bound to follow your advice, but my conscience does not actually allow me to sign. For this reason, I do not sign, or I will delay to sign if the issue may also be looked at from the point of delay. And then that's when the draftsman said, in that event, well, King, you sign or you don't, the Prime Minister will sign on your behalf, and it will be taken as if it was done by you. For history and for record purposes, we know for a fact now and today that, in fact, this prorogation, it was the advice of the Prime Minister. The King was given an unreasonable time of less than 3 hours, 18 hours to 9 p.m. And within those 3 hours, unreasonably short time, the PM made the decision on behalf of the King because the King was wasting his time, or he was declining. Whichever way it may be, the fact of the matter is the law says then you are enjoined in terms of section 87.3 that you should then, may I go back to the section verbatim? I apologize, the relevant section is not 87, it is section 91, subsection 3, which says, in that event then, you are bound, Prime Minister, to report to the Parliament. I wish to make the following submission briefly, Your Lordships and Ladyship.
Mr. Mulati, I read your papers.
Yes, Lord.
Is it a fair summary of your case that you are only intervening on the sole ground that the Prime Minister failed to report?
That is so.
In other words, you accept for purposes of your case that the King never signed?
That is so, my Lord.
That's the only reason why?
Yes, because my clients are saying.
The Prime Minister went to 93.
That is so, my Lord.
So the only argument that you are really projecting now is that the Prime Minister failed in his reporting obligations to Parliament.
That is so, my Lord.
Whether or not the King refused and did all these other things you are saying, that might be so, but he was obliged to report.
He was obliged to report.
Okay.
And my clients are saying, as people who are parliamentarians, and from the party perspective, we are the main opposition party, we ought to have received the benefit of this report. For the fact that this section, there is non-compliance to that extent, this prorogation is improper. That is the long and short of the intervener's case. I do not wish to belabor it any further than what is contained in our heads of arguments. We rely on the Miller case similarly.
What would be the mechanics of the reporting if the effect of prorogation is to put a stop or suspend Parliament?
Well, my Lord, I would look at it from various ways. One such means would be, much as the interveners say, because we are still actually expecting that even the issue of prorogation, we will be told about it even in a formal parliamentary sitting. At least following this decision that was made during the night over the weekend, next the following Monday, we would be informed that, well, in fact, much as the House was prepared to come and deal with its normal business, we are here to inform you that, in fact, the Parliament has been prorogated. Room was still open for the next following Monday for that business to be transacted.
Differently, Mr. Mulat.
Yes, my Lord.
The Constitution, in terms of Section 91(3), envisages a situation where Parliament is prorogued with immediate effect.
I submit no. For one simple reason, Your Lordship. The parliamentarians, in terms of this very Constitution, they should actually know that, in fact, the decision or the intention to prorogue Parliament exists. Because their business, in terms of the Miller principle, is the work of the Parliament, which should, in fact, continue insofar as possible, cannot be lightly stopped at the stroke of the pen without there being a proper justification, to which reasonableness would say, well, even if they were consulted, at least this is something that they could have actually given green light to. That is my submission, my Lord. Beyond that, my Lords and my Lady, I have no further questions. I have submissions.
Thank you. Yes, Mr.
My Lords and Lady.
I suppose you'll start where you said you start in your heads. Because I know somewhere in the middle of your heads you said, let's start now, we are starting. Or maybe having had the debate, you want to take a different approach.
I really don't want to, go into the details of my head, really.
Okay.
The only things that I want to address slightly more meaningfully is the question of locus standi, because the issue of legality, I think I'm not going to take more than 15 minutes doing that. My Lords and Lady, the aspect of locus standi, you will realize that, as pleaded on the papers, locus standi is said to be based on Section 20 and Section 22. Could I refer the court to page 7 of the founding affidavit? It is there stated that the first and third applicants are approaching this court pursuant to the provisions of Section 20 of the Constitution of Lesotho, as amended, read with the Societies Act, and as for the fourth to the seventh applicants come before this court to seek redress in terms of Section 22 of the Constitution. Now, my Lords and Lady, we have made a very, I don't want to go into the details of the submissions. We make the point that insofar as the issue of prorogation is concerned, it does not affect political parties, if we start with political parties. The exercise of executive powers has got nothing to do with political parties. I think what the applicants fail to understand is that when once the Prime Minister has been elected and installed and sworn in as Prime Minister, the umbilical cord is cut literally from the point of view of being Prime Minister for the party, but it's Prime Minister for the whole country. And, so that the suggestion that because ABC had 250,000 voters voting on, voting it for it, does not assist at all. When the Prime Minister acts, he acts on behalf of the other millions of people who did not vote. So I submit that political parties have got no standing whatsoever. I've made the point, I'll just go through these points very quickly so that I don't take up time. I've made the point that the reliance on Section 20 of the Constitution actually is misplaced, because if you look at Section 20, the section itself specifically, deals with certain rights, and those rights may be exercised according to A, directly or indirectly. It says every citizen of Lesotho shall enjoy the right A, to take part in the conduct of public affairs directly or through freely chosen representatives. They are not complaining that they've been prevented from taking, exercising this right. In any event, we are not even being told that the exercise of the powers in terms of Section 91 or Section 83 by the Prime Minister involves, or implicates this section. I submit that it doesn't. I've also referred your lordships to the fact that those rights are subject to the rights that are contained in 21 are subject to subsection to the other provisions of the Constitution. Now, the other provisions of the Constitution means that where the Prime Minister exercises the powers pursuant to a particular provision, to the extent that it is not contemplated that Section 20 shall come into operation, then there is inconsistency to that effect, and the Prime Minister would then act in terms of that section without violating the provisions of Section 21.
But are you not? Is it not a wide proposition, Mr. Taylor? If you consider that we are a democracy,
yes,
and the machinery through which this is operationalized is associations,
yes,
political associations,
yes,
which are political parties. And those political parties are represented in Parliament.
That is when...
At the level of caucuses, isn't
yes,
it?
Yes.
And they are the ones that really sponsor even members of Parliament to go into Parliament. Is it not putting it too widely to say, too broadly, to say they have no interest at all in whether or not the people they sponsored in Parliament, their voices has been shut?
Well, they have a political interest, but not a legal interest. There can be no doubt about that.
What, the parties?
Yes, they do have a political interest, but not a legal interest.
No, in Parliament, I'm saying in Parliament where they are participating.
Yes, even
Or are you saying they don't participate in Parliament?
No, they are participating in Parliament. In fact, they are enjoying that very right.
Yes.
In terms of 20, subsection 1. They are freely chosen representatives. But now the question is, are those representatives also endowed with the power to invoke the machinery of Section 83 as well as 91? They are not. The deliberate scheme of the Constitution is to say, you participate in certain structures where people who are elected participate in Parliament. But insofar as executive power is concerned, which is not parliamentary power,
yes,
executive power is concerned, that is bestowed upon the Prime Minister, which is what he's exercising. So in other words, it is not broadly stated to the extent that what is being discussed here is the exercise of executive power.
Now, if that exercise of the executive power has the effect of actually closing down the voice of elected representatives through which citizens participate in government in terms of 20, don't they have an interest to that extent to say, well, you enjoy executive powers,
yes, but
we are here to represent millions of people here through a democratic process. Therefore, in that context, we are affected. Because they cannot turn around and say, well, we are MPs, but if the PM shuts down Parliament, then let the people decide.
Well, the interest, I go back to the interest, and perhaps I should then hasten to go to the case law because...
Yes, please.
Yes, I'll hasten to go to the case law because your Lordship will see that once they claim interest, it must be a legal interest that is cognizable for purpose of standing in a court of law. And that has been interpreted in the context of Section 22, subsection 1 by the Court of Appeal, that in a restricted manner, that they have to demonstrate that the contravention of the rights or whatever is inconsistent action is in relation to themselves. And my lords and lady, I'm not a particular supporter of the restricted interpretation, but I have no choice. The Court of Appeal has said that is the law. Now, they have to demonstrate what is it that in relation to themselves is affected by the exercise of executive power in terms of 83 and 91, in relation to themselves. as political parties.
So the approach
Yes.
of that, that proposition seems to suggest that political parties are rendered irrelevant, albeit they're in Parliament. They are rendered irrelevant when it comes to the enforcement of the Constitution.
That is the effect of the judgment.
Yeah, of the judgment.
Yes, that is the effect of the judgments. And what I like that effect or not is another matter. But the Court of Appeal has said that's how it must be understood. When you look at Section 22, subsection 1, you must say it is in relation to yourself. There's a case which I've referred to,
That's the paradigm of private law locus standi.
Yes, exactly.
But don't we have then the other paradigm of public law paradigm, i.e. where you can litigate on the basis of the rule of law?
Yes.
Not necessarily alleging contravention of the Bill of Rights, which seems what the Court of Appeal seems to have been preoccupied with. Complaints about allegation of Chapter 3 of the Constitution. In other words, you cannot complain outside Chapter 3. No one can complain, and the net effect would be that the Prime Minister, when he exercises executive powers, no one can complain.
That is exactly
because that doesn't affect them.
Yes, my lord. My instructing attorney, in the case that I've referred the court to, tried in vain to try and explain that, well, even as a party in the proceedings where the state had appeared to interfere with the constitution or the composition of the Court of Appeal, in a case that was supposed to be in relation to himself, and one of the parties is one that I share the heart with, it was said, no, but you don't have any interest in the appointment of the position of the President of the Court of Appeal. It matters not that it has the effect of affecting whatever it is that, whatever happens in between affects your interest. It doesn't matter. Did
the Law Society have an interest?
Well,
did they say, well, you are a member of the Law Society, therefore it's your society or the executive which can decide?
Yes, there was talk about the Law Society.
Yes.
But it wasn't that only it could have standing.
According to the approach of the Court of Appeal, would it have made a difference if instead of the applicant therein, it was the Law Society which was suing?
Yes, possibly so. I don't want to speculate about that.
Yes.
But the fact of the matter, I'm trying to demonstrate that the difficulty that the applicants have placed themselves in, and they made their bed and must lie on it, it is that they are pleading the rights under Chapter 2. And if you plead rights under Chapter 2, then you are constricted by the approach of the Court of Appeal in the judgments that I've referred to, in the Dr. Masito matter and the Judge Lajwane matter. You are confined to that. Remember, my lords and ladies,
that you should be a natural person.
And also it must be a natural person.
So if you are not a natural person, you cannot complain.
Your Lordship, I recall that you delivered a judgment in the DPE matter where I appeared. And I had no problem in saying, well, DPE had locus
TRC.
Yeah, the TRC. Sorry.
Yeah, the TRC matter,
that it had standing.
Yes.
But you see, the fact of the matter is that the matter was not taken up on appeal. But when you look at the judgments that now still operate, and the Court of Appeal is very adamant that its decisions must be followed to the letter. Because in the judgments, in the latest of those judgments, the Court of Appeal said it's actually judicial misconduct or incompetence for our judgments not to be followed.
But they can't be followed to the letter with respect because every case has its own peculiar facts. What we can follow are legal propositions.
Well,
not actually the context in which those cases were decided.
Well, it has now been...
Throughout the world, I'm not aware that if a court says this case is distinguishable, that's judicial misconduct. Wouldn't the Court of Appeal be going too far to say, well, this is a straight jacket. We said this, well, thou shalt follow it. Whether or not there's a sound submission from counsel to say, we beg the court to distinguish the case.
You see, the difficulty that the applicants put themselves in here is that, however, they have not pleaded, legality review under Section 2, read with the other section.
Right, yeah. Rule of law review.
Yes.
Yes.
Rule of law, sorry.
Yeah, rule of law review.
Rule of law review.
Yeah.
They've not done that. They've chosen the bed and they've made it, they must lie on it. They are saying we are relying on the Chapter 2 rights. And in terms of the Chapter 2 rights, then they are caught by the restrictive approach. So it becomes important as to what has been pleaded so that you distinguish on the basis of what has been pleaded.
But what are they complaining about? They might refer to 22, but aren't they complaining about something outside Chapter 3?
There are difficulties that then they have not put the legal nexus or the factual nexus between the Chapter 2 rights and that executive power, exercise of executive power. That is a difficulty. So if they were pleading, you see, they could not make that connection precisely because they were purely concerned about what their rights are under Chapter 2.
Don't you think, Ms. Taylor, they did that because of the Court of Appeal judgment?
Yes, now they're stuck.
That they were stuck, that, well, the Court of Appeal says, thou shalt only complain about constitutional violation if you are alleging a Bill of Rights contravention.
Yes.
In other words, they said, how could we plead outside?
Yes, perhaps.
I suppose they were not aware of the TRC judgment.
Well, perhaps so, but now they have pleaded, they have made their bed, as I said, they must lie on it. They must lie on it. That is what they have pleaded. They have said, we are pleading Chapter 2 rights. Now, it must now be found out what is the nature of the Chapter 2 right that has been violated. Now, and that then says, in relation to themselves, that is what has to happen. And I submit that they are not able to do that in relation to themselves.
What happens where a party quotes a wrong law? He quotes a wrong law for purposes of the remedy seeking.
Well, what happens is that if he also now pleads the correct facts,
yes,
then you can do the right law.
That's what I'm saying. If he pleads the correct facts,
yeah, the correct,
but he quoted the wrong law,
yes,
and the court isn't the court supposed to say, well, he relied on the wrong section. The right section is this one, given the facts that he has pleaded.
They have not pleaded the correct facts in the sense that they would have to go further to say, in terms of our Chapter 2 rights, this is what has happened, or we are not dealing with that. We are not dealing with the Chapter 2 rights. We are dealing with the rule of law review. We are concerned that in terms of Section 2 of the Constitution, the supremacy clause has been violated, and things like that. This is not what they have done. And you will find, you look at all the arguments that they have tried to advance, they have not said so. I speculated in their favor, like your lordship is saying, but they haven't said so, even from the bar. They have not said so. In other words, they would be asking that this court be kind to them and amend their pleadings, because an affidavit is both pleadings and evidence.
And not the facts. The facts we cannot panel beat them, isn't it?
You cannot panel beat them.
I cannot panel beat
No,
the
you
facts.
cannot panel beat them to suit a particular.
Yeah, but I merely say if a party is mistaken, he says, I have a certain right under that section. When you read the case, you find, no, his right is actually this one.
No, you can't say his right is this one, because
on the
he hasn't demonstrated. He has first to demonstrate it.
Yeah, on the
Once he has demonstrated, then you can say, well, perhaps his right is this one. Yeah. The difficulty is that, you see, he would have to then mold the facts in such a way that they demonstrate the right.
Yeah.
But they have not demonstrated how it is that they believe that everywhere in the world, including the judgment on which they rely, only the Prime Minister and he alone advise his cabinet. He need not consult anyone. He need not, consult cabinet. He need not consult partners. He only talks to His Majesty. I'm going to come to that. But the point I'm trying to make is that they themselves have not done that. They have not tried to put together a case that now transcends the Chapter 2 rights into the rule of law review. They have not done so. I'm all for rule of law review. I've argued many cases, and I felt embarrassed when the Court of Appeal judgments came out with respect, because I thought then I'd been wrong all the time. I know that his Lordship Justice Mukherjee will remember that I made a lot of noises in one of the matters that I appeared before him on the matter. So if the court is prepared, but the difficulty...
So in short, you are saying there's no nexus between their capacity to litigate and their final relief, the final relief that they're seeking.
they're asking for. That's in essence what I'm saying.
Who would be qualified to assert, to claim these reliefs in the context of the issues that are before us, i.e. prorogation of Parliament, which is an assembly of elected representatives in terms of Section 20?
But let me just say the political parties must necessarily go away immediately. They have no locus standi. Perhaps if
because they are not in Parliament, are you saying that?
They have their representative in Parliament, so perhaps their representatives could come to court and complain, which then would mean a different matter insofar as the other applicants are concerned who are members of Parliament. Who are members of Parliament? Because they exercise the rights under 21A directly or indirectly. And then if we talk about indirectly, then they would be exercising those rights in terms, through the chosen representatives who will be the members of Parliament.
Yeah.
But only to the extent, my lord and lady, and it is usually very frustrating to argue cases in situations of this nature. As I said, I subscribe to the view that the rule of law review should be encouraged. It's something that ought to be encouraged. That has to be held to be in existence. Exactly the situation that was going on in the cases where the constricted or the strict interpretation of Section 22 was held. I submit that it becomes difficult. But I would be prepared for purposes of at least insofar as this matter is of such public importance, to say, well, perhaps your lordship would be, would not be going too far in saying, well, we will assume that the members of Parliament are, instituting a rule of law review, as opposed to what is being suggested. And then we can then get into the issues. But it is my humble submission that if we were to follow the judgments of the Court of Appeal, which the judgments themselves say we must follow to the letter, then that would not have happened.
So you are submitting we should follow it to the letter? Despite the weightiness, constitutional weightiness of the issues being raised.
No, I'm not. I'm saying insofar as the parliamentarians are concerned, I'm not asking you to follow it to the letter.
Okay.
But insofar as the political parties are concerned, I'm asking you to do so. Precisely because you get the sort of pejorative and derogatory language that you get when you get politicians coming before this court to litigate matters of state. This is exactly what causes the problem.
No, the genesis of the problem of what engenders what you are saying is the coalition agreement.
No, but incidentally, that is the...
Because it's, as I understood the approach of the applicants,
yes.
They were saying the Prime Minister dare not be an unruly horse. Yes. There's a bridle. Yes. That bridle is the coalition agreement.
Yeah,
he should always be coming back to us. When he goes forward, before he takes a step, consult.
Yes. No, but they
when returning,
yes.
Report.
They extended to say, and I'm not a student of politics or political science. They are saying this is not a one-party state, therefore he must consult. But I would have thought that it was in a one-party state. The position of the party is the position of the government. So they are arguing the converse. It is my humble submission that in any event, you would be quite, right with respect if you were to assume that, well, the parliamentarians were probably thinking of the rule of law review.
Yeah.
I even suspected at some point, thinking to myself that maybe when they said the 4th to 7th are approaching on the basis of Section 22, I thought maybe the 2 was added as a typo. I thought so. Haven't
they referred to 119 anyway? Section 119 of the Constitution?
I think there is some reference,
Yeah.
some glib reference to it.
Yeah, what do you think about 119?
Section 119. If I could just find it quickly. That is 4.
Sorry,
Paragraph 4 at page 9.
page 9.
They say the cause of action, as you shall hereunder be demonstrated, arose within territorial jurisdiction of this court, and all the relief sought fall within purview of Section 119 of the Constitution, read with Section 2 of the Constitution, and read with Act Number 5 of 1978, and the constitutional litigation rules.
So the jurisdiction that they are invoking is a 119 jurisdiction?
Yes, to that extent.
Yes.
To that extent.
Yeah.
And
that would be a rule of law review, isn't it?
it would be a rule of law review.
Not a Section 22, or not a contravention of Bill of
The
Rights.
Chapter 2, yes, the
Yes.
Chapter 2 review.
Yes.
Yes. So
What do you say about that one?
I've already said, my lord, even the rule of law review, insofar as the political parties are concerned, that I submit, they would not have any locus standi to do so. But the members of parliament would in any event be allowed to proceed in terms of the rule of law, to the extent that they've got sufficient interest, which is a different matter from direct and substantial interest that the judgments of the Court of Appeal are talking about.
Yes.
But it is this matters, my lords, and it's important that this particular matters be projected in your judgments, because we struggle as legal practitioners to advise clients. How do you proceed? How do you proceed? You've got judgments of the High Court, of the Constitutional Court, that have not been appealed. They still stand. When the matters are argued in the Court of Appeal, they are not referred to. There is nothing that is said about them. The position of the law, as I understand it, I may be wrong, is that even a judgment of a lower court which has been standing for a long time, pursuant to which people have ordered their affairs in accordance with that judgment, cannot just be lightly set aside. Now, which was a different thing altogether when the rule of law review was invoked by my instructing attorney in the matter where he was challenging the appointment of the President of the Court of Appeal. It was that is, you have no business coming here. You have to have a right in terms of Chapter 2. Unless you come under Chapter 2, then that's the end of the matter.
Hence, that's why I asked, was the better judgment referred to and discussed in that matter?
Many other judgments were not discussed, including the Law Society versus the Minister of Defense. You remember in that judgment, Chief Justice Carlin, actually referred with approval to the jurisprudence in Canada, referred to Thorson judgment and other judgments, that in certain circumstances you do not allow an illegality to continue unchallenged because there's no one who's got standing. He approved of that decision. But this is the difficulty that I wanted to project. I think I've done quite enough, and I'll pass to the matter.
Yeah, we look at those judgments, all of them, and then, But as far as MPs are concerned, you are saying we should assume they are before court.
Assume that they have sufficient interest.
Yes, okay.
In any event, we want a decision on the merits, because we
Yes.
want a decision on the merits of this matter.
Okay.
Yes. How long is this lordship, and your lordship is going to allow me to continue?
I don't know how long you are going to take,
No,
Ms.
I'm
Taylor.
not going to take long.
Yeah, if we can, let's just see. On Friday, we started late today anyway.
Yes,
Can we go by 1:30? You think you might be done?
I think so.
Okay. It would be better so that we deal with this issue once and for all, this case once and for all.
My lord and lady, the issue is very straightforward.
No, non-joinder,
Non-joinder.
the speaker.
Well, I've already said, the speaker was a necessary party, but I've already said we want a decision on the merits. So
we need not pronounce ourselves on non-joinder of the speaker.
I submit with respect that you can mention, if you want me to make just short submissions, I'll do so very briefly on the non-joinder, but not necessarily that the application be dismissed on that account, because we still want to have a decision on the merits.
Then you can proceed on the merits then.
Yes. Perhaps if I can just say one word about the speaker very briefly. It is that the speaker, he's actually the person who runs the parliament as the presiding officer. And questions of meetings of parliament, those are called by him in consultation with the government. So he's an important person insofar as meetings are concerned, of parliament is concerned. This is, it would not have been necessary, for example, for my learned friend, Mr. Moladi's clients to be saying they were chased away by armed policemen and so on and so forth. What happens is that there's always communication between government and the speaker, because the issues affecting the meetings of parliament are always liaised between the speaker and the government.
So are you saying we should assume that the Prime Minister talked to the speaker about the Gazette over the weekend?
Yes, and he would most definitely have done something to discuss the issue. He can't just...
If that is the case, shouldn't the speaker immediately through the clerk to have said to members of parliament,
yes,
I've been so informed, therefore don't bother to come?
That is the point. That's actually what happens and what should happen. But now we are not going to talk about the competence or incompetence of the speaker or his clerks in his absence. That's the problem. Because they ought to have brought him here so that he can enlighten the court as to what happened in relation to this prorogation. And his Lordship presiding correctly pointed out there are no formalities insofar as prorogation is concerned, where there would be a formal sitting, and then, as in the UK, and then the parliament is prorogued.
Is he a member of parliament?
Well, this one is not.
This
particular one is not a member.
He's not a member.
Yeah, this one is not a member.
Yeah, so he'd be saying, well, I'm not a member, therefore. If the Prime Minister decides to chase you away,
no,
everything is, your rights are the ones that are being...
No.
Because he's merely a preside. They'll call him to come and preside as to MPs. If there is a speaker, come here. There's a declarator here, no. Come and preside. No. Unlike the one who's an MP, he would know that, no. Actually, I'm representing people here, and the PM can't just say that. But if the PM communicates to a speaker who's not a member, the speaker isn't entitled to say, well, if that's what the PM wants, so be it.
Well, your Lordship should be careful lest he appears to discourage election of a speaker other than a member. The Constitution allows for it, but...
No, I'm not even suggesting that. It's only that the speaker who's an MP, I would assume that he would, like other MPs, have decided to do something about the matter, not to be joined as a respondent.
He probably did. Remember, we have not answered anything concerning Mr. Mulati's allegations.
Okay.
We have not answered anything.
All right.
But I was simply saying, in the future, there certainly would be, a propriety. If he's not a necessary party, he no doubt would be one of the parties that must be joined.
So this is not a joinder of convenience, you are suggesting?
No, it is not a joinder of convenience. It would be a necessary party. But
that's not where you are.
I'm not there now, because I think the Prime Minister wants a decision on the merits.
Yes, let's go.
Of this matter, because it has generated too much negative publicity for comfort. To the merits.
Before you proceed, on the second prong of your attack on the question of locus standi, you raise an argument that the artisans are not suited on the basis that Section 20 is subject to other provisions.
Yes.
How is that linked to the issue of standi? Does the fact that the right under Section 20 is subject to other rights non-suit the applicant?
What happens is that locus standi is never interrogated in vacuum. It has to be in relation to your rights in the subject matter. And the subject matter is defined by the claim that you're making. And the claim that you're making, if it is based on a particular section that does not extend to what His Lordship presiding has referred to a rule of law review, then it's a different matter. Because then it restricts them to a particular criteria of ability to come to court. This is so in other words, my direct answer to your Lordship's question is that locus standi is never interrogated in vacuum. It is always done in relation to the interest in the subject matter. And that subject matter, I mean, my children have an interest in the continuance of the marriage between me and their mother. But they have no locus standi to be talking about the marriage between me and their mother.
Between you and your wife?
And their mother. Yeah, and my wife. They've got no business complaining. So the subject matter also becomes very relevant for purposes. So I was making that submission in the context of the subject matter that you're dealing with. That locus standi, it's in relation to the subject matter of discussion. Now, if I could just then go to the merits. And I'm not going to follow the text because I want to finish quickly. The submissions I've made before you, your Lordships already have.
If I may, perhaps, of course, if you don't mind, Mr. Lede, if I may summarize my understanding
Yes.
of your defense, it is that the Prime Minister complied with the requirements of Section 91(3).
Subsection 3, yes.
That would presuppose that His Majesty failed to act as advised in terms of 83.
Yes.
Isn't it?
Yes.
Now, that failure to act, is it articulated anywhere in the pleadings?
It should not
that the king failed to act. We advised him pursuant to 83, then he failed to act, hence we then were constrained to resort to 91(3).
You see, that is the essence of this proceedings, and once I've answered that question, I'm done with my address.
Yeah.
The Constitution sets out the framework within which the question of advice to His Majesty by the Prime Minister and other functionaries of state has to be viewed. And let's start with, that is the exercise of executive powers in terms of Section 91 of the Constitution. The difficulty that I've seen with respect to my learned friends is that they read this section, they just zoom into one section and they don't read the whole of the section. Because the Constitution must not be read in that piecemeal fashion. It has to be read, at least the context in which the section appears becomes important. And if I may just go to Section 91, let me go to 3 directly. Where the king is required by this Constitution to do any act in accordance with the advice of any person or authority other than the Council of State, and the Prime Minister is satisfied that the king has not done that act, the Prime Minister may inform the king that it is the intention of the Prime Minister to do that act himself after the expiration of a period to be specified by the Prime Minister, specified to the king, I should say, by the Prime Minister. And if at the expiration of that period the king has not done the act, the Prime Minister may do the act himself and shall, at the earliest opportunity thereafter, report the matter in Parliament, and any act of the king so done by the Prime Minister shall be deemed to have been done by the king and to be his act. Then we have to remember that In this context, we are dealing with the advice tendered to His Majesty by the Prime Minister himself. So we go back to 83 and see what it is that he would have advised. He would have advised in terms of section 83, 1 read with 4. One says the King may at any time prorogue or dissolve Parliament. And then 4 says, in the exercise of his powers to dissolve or prorogue Parliament, the King shall act in accordance with the advice of the Prime Minister. Now,
would that mean that it's only a legally tenable advice that the King is enjoined to act in accordance with?
I'm going to come to that. The argument by scholars and in other jurisdictions is that prorogation is a reserve power, by which it is meant that it's a reserve power to the extent that the King may still, retains the discretion to act on his own deliberate judgment. But even those, in those jurisdictions, it is recognized that unless the Constitution does not allow for such interpretation, that there's a reserve power in prorogation. Now, it is immediately when you look at 91 subsection 3, you immediately find that then there's no reserve power because it allows for the overreach of His Majesty by the Prime Minister.
Yeah, that I understand.
Yes.
Where I am is simply this. The PM is supposed to advise, the King is constitutionally obliged to act in accordance with an advice.
Yes.
Does it mean that even if the advice itself goes against the Constitution, he's still obliged? The King cannot say, no, I'm not going to sign because the course of action that you are advising in respect of, it's illegal and unconstitutional. In other words, does the King does he not have a voice in the matter to say, look, I'm not going to do this, therefore leaving it to the Prime Minister to do it under 91.3?
Yes. No, I think, my Lord, we should not conflate the two situations. The King may decide not to act in accordance with the advice of the Prime Minister, not because he interposes himself as the person, entitled to judge whether the matter is legal or not. It may be for a number of reasons. It may be for a number of reasons which are unconnected to the question of legality or otherwise. But if you look at and I'm going to go to the history of this section, insofar as acting according to the advice of the Prime Minister is concerned. But what is important is that the advice itself would then be determined by, it is this court that would determine that. His obligation would be to act in accordance with the advice or refuse, as your Lordship correctly points out.
That's merely my interest, whether doesn't he have the right to say, this advice dare not cause me to contravene the Constitution, because after all, it is my constitutional responsibility as the King, the first citizen, to actually uphold the Constitution, even against the Prime Minister.
I caution with respect.
It's a matter of legal proposition, looking at the structure of the Constitution itself.
Well, the structure
the assumption is that the Prime Minister's advice should be lawful and constitutional.
Yes, the presumption is that.
Yes, that's the constitutional presumption.
In fact,
in other words, where it is not so, then the King might not follow that advice. And if the Prime Minister insists about it, then it is the Prime Minister who can do it in terms of 91.3.
No, with respect, my Lord, I think we have to step back a bit and say, the question is not whether the King may or may not refuse. I think the judgments in this jurisdiction, the Mukutu judgments and the McKennedy judgments, clearly show that he must act in accordance with the advice. But the fact of the matter is that at the end of the day, he has not been given that discretion. And it is not the issue of determining whether he can legally do so or not legally do so. Because it is not something that is justiciable. You cannot come to court and complain about it. So then it becomes...
That is under 91...
Subsection 5.
Yeah.
Yes.
Yeah. The outside clause.
Yes, the outside clause.
But would still retain jurisdiction to find out whether the Prime Minister himself had jurisdiction.
My point exactly. Point exactly.
So that would still have to judge whether what was done falls within the constitutional parameters or legal parameters.
With respect to Your Lordship, this is the point I'm making.
Yeah.
But then to arrive at the point where you now judge the exercise of the powers by the Prime Minister, you did not have determined whether His Majesty can or cannot accede to the advice. We know that the machinery is provided for under the Section 91. And Section 91 says you need not know what transpired between the First Minister and His Majesty. What happens between His Majesty and His First Minister stays in the palace. Nothing should be said about it.
We'll come to the secrecy. I'm just concerned about the rights of the monarch. Under 92, the right to be consulted, to warn, advise, and, to caution the Prime Minister. Doesn't that in itself suggest that His Majesty is not a rubber stamp?
Well, Your Lordship, I can only refer back to...
In other words, you cannot come to me and say, because I'm the Prime Minister, in terms of the Constitution, you are bound to follow my advice, do this. Doesn't the King doesn't he have a voice? Of course, ultimately...
No, he doesn't have a constitutional voice.
No, but
that's
I'm saying... But it would mean then the rights under 92 and as propounded
91.
92.
Okay, 92, okay.
As propounded in Makene versus Lachanya, would mean that we are throwing them overboard, because even then, although we didn't have a constitution, but the Cardinal CJ said, well, this being a constitutional monarch, even if the chairman of the military council fires a minister, and tenders an advice in that regard, it doesn't necessarily mean the king has no right to warn him, to encourage him.
The judgment you would make, and I submit with respect that in constitutional matters you decide so much as is necessary for decision in that particular case.
Yes.
Now, you will not be called upon to make that decision yourselves. We are not rejecting the dictum that Cardinal CJ made in the Magnetus matter.
Yes.
But it is not necessary for you to make that determination now, because the circumstances are such that you don't have all the facts, because of the developments after the Magnetic judgment itself in terms of this constitution, which then creates a buffer of secrecy around what happens in the palace. In other words, you cannot investigate that. Most of the arguments that were advanced on Friday afternoon and part of this morning have revolved around matters that ought not to be investigated in a court of law in terms of 91.5 as well as 55.8.
We need not go to 83, isn't it?
No.
This case is about 91.3.
Yes, I was.
And if it's about 91.3, the only inquiry is whether or not your client complied with 91.3.
With the requirements, yes.
Yes.
But remember, Your Lordship, I went to 83 because then I was trying to link and to answer the concerns of His Lordship, whether His Majesty has got any rights in relation to the matter. Then I'm respectfully submitting that you need not decide that today or any other time.
But we can assume, isn't it?
You can assume.
In terms of 92?
Yes, you can assume.
Yeah, that 92 confers him with the king with certain constitutional powers.
Yes.
So the advice when it is tendered, or 83 doesn't supplant 92.
Yes, it doesn't.
It doesn't mean that because the PM has tendered an advice, the king need not exercise his rights under the matter, in the matter.
Remembering, I think the quandary is created by the fact that people who come before you today, and make these affidavits are not depositing these affidavits as applicants. Minister Chief Masribana and Minister Ranzu. They are not coming to you as applicants, so that they could have been engaged directly if they were to be applicants. That okay, if you're saying, well, we will go beyond the veil of secrecy and do what we do as applicants in our own interest, and then we would have had to deal with those. Because at the end of the day, then there are applicants who are saying, our rights depend on this. And then we would have dealt with that. But that is the difficulty that's created where this is brought in by the side wind. Now, I was saying, my lord, to go back to section 91, subsection 3. I just wanted others to then say, in terms of that section, the Prime Minister, it would be presumed that he did consult, that the requirements did happen. But the question is, should he tell this court, I went to His Majesty, and I said, Your Majesty, I advise that you prorogue Parliament. And then His Majesty said, no, I will not do so. Or His Majesty said, well, do it yourself. Should that be what should be happening? It should not happen because that discussion between him and His Majesty, it's privileged. In fact, my and friends.
Are you saying it's privileged vis-a-vis the MPs?
It should not be discussed. It should not be inquired into in a court of law. So 95(5) says, without prejudice to the generality of section 155(8) of this constitution, where the king is required by this constitution to act in accordance with the advice of any person or authority, the question whether he has received or acted in accordance.
The Prime Minister is supposed to tell those things to Parliament. Even if the section says, well, those should not
I'll come to that.
But Parliament certainly should be told that there was an advice, he failed to act, I gave him time to consider the matter, he still failed to act, and I then invoked section 91, and I'm here to report to you parliamentarians that.
That's another leg of the argument. That's another leg of the argument, which is propounded.
So here you are only talking about what transpired between the Prime Minister and His Majesty.
Yes, my lord.
Okay.
And I'm saying, none of us has got good ears enough to hear what happened between His Majesty and His First Minister in terms of section 155, 91, subsection 5.
Isn't the problem that your client dragged them along?
Well, it is not.
He says, come,
it is not a problem.
I'm going to advise His Majesty, you come along. Of course, he might have assumed that, well, they'll keep the secrets. But they say, no, we are going to let the cat out of the bag. Because we disagree fundamentally with what the Prime Minister is saying.
It is not a problem. What is the problem is that they are approbating and reprobating. They say, when you advise His Majesty, you must talk to us. When they are brought along, they complain, they say, well, we should not have been there. And then they start saying, he brought in Zeke. We don't know who Zeke is. They brought in Zeke. But that is not the point. The point is, their case, which is what we are here to meet, is that we you see, I am not going to.
I understand 91.5 say, yes. 91.5 says what the briefings between the PM and the King are not open to judicial inquiry.
Yes.
Because the convention, as I understand it in England, is that in fact there is even no record. That's what the authorities say.
Yes.
There's no record, no minutes or anything. It's just the Prime Minister briefing the King and perhaps having a discussion.
And
now, here, there's a little bit of a problem, i.e., that your client goes to these briefings with them. Later, I don't know when, you are still going to address me.
Yes.
He reduces
ABC1.
He reduces the advice to writing.
In writing, yes.
So the assumption is that what the PM reduces to writing is exactly what he briefed the King about.
Yes, you can only speculate, yes.
No, but is it not a fair? is not a fair?
It's a fair speculation.
A fair inference to draw that, well, if he did advise in relation to Corona, as he's saying,
yes,
when they met, he should have verbally so advised. So
yes,
it's just been reduced to writing.
Yes, that's true.
And then maybe he's doing so because of the disagreement that he had with the other coalition partners. Because they give me an impression, that is the applicants, that once they raised an objection or they felt uncomfortable, there was a necessity to retreat. And then the expectation was that they would regroup.
Yes.
And maybe it's within that context that the king did not sign or failed to act.
Yes. Now, I think, my lord, let's keep them apart. Let's talk first about the consultation with the coalition partners.
Yes.
I am saying, my lord, you had asked me, isn't the problem caused by the Prime Minister by bringing these people along with him? But I am saying the problem is created by the fact that when they are brought along on a matter which they say they have every right to participate in, then when they hear the arguments in court, they now backtrack and say, well, we ought not have been brought in. But the fact of the matter is that then it creates a dispute of fact as to whether they were told and not told. Now, the Plascon Evans Payne's rule would apply in favor of the Prime Minister, that you take the version of the Prime Minister. But it's even worse. It's even worse in the sense that in terms of the Constitution itself, even where there's a requirement for a consultation, not advice, the person who's consulting need not act in accordance with the advice of the person who's consulted. And whether that consultation happened or not can also not be investigated in the court of law. 155.8. So they meet a double hurdle. The first hurdle is that either they were consulted. If they were not consulted, if there's a dispute that they were not consulted, then Plascon Evans Payne's rule applies against them, that they were consulted. If they say, well, in any event we're entitled to consultation, they cannot say, well, we ought to have he ought to have agreed with our stance in the matter. Your Lordship, just before I leave the question of consultation, you'll remember in the judgment of the President of the Court of Appeal and the Prime Minister, I think he's the only one called in that fashion, the other president, not the present president. Your Lordship will remember the case that what had happened there was that there was no hearing that had been given. And one of the things that the Court of Appeal dealt with was, okay, but now you also saw the affidavits, the grounds upon which you would have been asked to make representations have been put forward in an affidavit. You've had opportunity to deal with them. What different answer would you have given? If I use that analogy, I want to submit that in any event, they would have been consulted. If they were at a meeting which they ought not to have been in attendance, they add their views. What more do they want? Do they want the Prime Minister now to agree with them? But the powers to advise the Prime Minister, even in terms of the judgments, is the exclusive domain or remit of the Prime Minister.
But as I understood the argument now, at the end of the day, was simply that they are raising that issue only insofar as they are saying the reason that the Prime Minister gave to prorogue. In fact, the prorogation itself, the advice in that regard was unwarranted and not called for, because the understanding was that, no, the cabinet decision is the one that operates. So they didn't contemplate the PM now saying to the king, lock down Parliament.
Well,
that's really how I, at the end of the day, I understood.
Well, of course.
And they say to the extent that the PM locked down Parliament, you see.
Well,
as far as they are being partners in government, they say that was wrong.
Yes, of course, I've already addressed
Yeah,
that
you have
aspect.
already addressed that.
That it doesn't matter.
So at the end of the day,
aspirations don't
really,
matter.
yeah, so at the end of the day, really, we are now in 91.3.
Yes.
That has been done, rightly or wrongly.
Yes.
It has now been done.
Yeah, now it is been
the
done.
issue is now in relation to the case of Mr. Molati.
Yes, I'll deal with that.
Yeah.
Can I just quickly
Yes.
reiterate our reliance also
Yes,
on
yes.
as far as Cabinet is concerned on the judgment which I think was put to my learned friends, the Attorney General and His Majesty, which I submit resolves the issue of Cabinet. If I don't see how there will be any obligation to consult the coalition partners if it is not an obligation to consult Cabinet. Can I just then go to the case of Mr. Molati? But before I do that, my Lord, I just want to stress the point, and I don't think I can stress it enough, that the entire arguments that were addressed before you on Friday and this morning were in total breach of the provisions of 915 and 1558. This is why then people, there was suggestion about ultimatums, this and that. That is not a matter that they ought to have. We should not even have come to that point because that inquiry should not have been gone into. Now let's go to the material.
The problem is ABC1.
No, ABC1.
They are saying all this is because of ABC1. They say you look at ABC1. What the Prime Minister does, he actually, as it were, holds a sword on the head of His Majesty to say, by 9 o'clock, you should give me an answer.
It is their problem because they have brought that document, which we say it's privileged. But we have said we want the decision because in the end, with respect, I agree with the court that with respect, what has to be interrogated now, it's the justification. But they have already disclosed information that ought not to have been disclosed. It's there. We have it. Because a written advice is advice. It's covered by those provisions. But we're saying, but let's work on the justification that has been put forward in that advice. And it's coronavirus.
But once aren't you approbate and reprobate if you say it's privileged, but since it talks about coronavirus, let's assume that that's the reason.
Do I understand you to be now saying, well, I disavow...
to the extent that coronavirus is mentioned.
Well, my reliance on the fact that this document ABC1 should be disqualified.
There are two ways to look at it.
Yeah.
And I think perhaps that addresses one of the questions that was asked by His Lordship Justice Mkhesi earlier on Friday. That one way is that when you look at the advice, what is excluded is advice, not the material upon which the advice is given. Now, that material may be put forward by the minister responsible who gave the advice, being the Prime Minister, in a form of an affidavit that I was relying on this particular facts. And one of those facts, including the cabinet document, Annexure A1, talks of coronavirus. So, from the point of view of how the reason, then incidentally, the reason is part of the advice. But we're saying the question of the coronavirus is the actual ground upon, or the material upon which we're saying to His Majesty, prorogation need to happen. It is common cause. Even from the meetings that we had, where there's a dispute, it is common cause that is the pandemic of the coronavirus, which caused the advice. So that is the material that is there, which is available to the court to interrogate and to look at.
My understanding of ABC1 is that is an advice and material rolled into one.
Rolled into one, yes, that is correct.
Now, if you claim executive privilege,
yes,
it would mean that would have to, as it were, sever
No, we don't want you to say...
Maybe paragraph 1, since it's an advice,
Yeah.
and the other one, which is actually reference to
Yes.
cabinet.
Yes, you're right, Your Lordship, that it's rolled into one.
Yes.
Being rolled into one then poses the problem that if for the first respondent to prove his case, he requires that document to be before you. This is why I'm saying we are, if you look at the affidavits, we are saying the deliberations must be excluded, insofar as what transpired in the presence of the coalition partners and the Prime Minister must be excluded, because those are not admissible altogether.
So at the end of the day, really, we should only, for your purposes of your defense,
Yes.
ask of you, what are the reasons?
Exactly.
And are they justifiable?
Exactly, yes.
And where do we get those reasons in your papers?
Yes. Yes. The reason is the pandemic. The threat, the existential threat of
COVID-19.
the corona pandemic.
And COVID-19,
It's the same thing.
according to the documents,
Yes.
is articulated in the cabinet decision.
Yes, it's in ABC 1.
Is there in ABC 1?
It's, ABC 1,
Yeah.
which is page 30, I think.
ABC 1.
It's there in ABC 1, page 30. It's also there in A1, which is page 82.
Yes.
It is also dealt with in the affidavit of the Prime Minister in detail. Page 63 to 63 to 65. It's well articulated that the Prime Minister says, I felt impelled or compelled to advise His Majesty to prorogue Parliament because of the pandemic, the coronavirus pandemic. Now, the question is then, is it justified? I submit that even when you look at the decision, the minutes of cabinet itself, that justifies the decision that was taken by the Prime Minister to prorogue. Because this targets meetings. I mean, every individual is locked into his house, and the expectation is that members of Parliament would then continue to go on with their business as usual.
But that in itself is not wrong, isn't it?
Sorry?
That in itself, if they continue transacting parliamentary business, it's not in itself wrong. What would be wrong is if they assemble there and there are more than 50. And
you can be sure, my lord, that there are more than 50.
Why?
Members of Parliament are 120,
But why couldn't they assemble in terms of committees?
You see, my lord, I think that takes me to a separate point, but I think we have to start first with the justification in relation to the totality of them. And then we'll go to the committees. The totality of them exceeds the advisory that government has received in relation to meetings of individuals. And I submit that it's a proper justification for there to be this step taken. Now, it cannot be that members of Parliament are immune from the risks that are posed, or that we will have to have the risk spread from Parliament merely because they are members of Parliament.
But wouldn't they, if your client said, well, colleagues, because he's also a member of Parliament,
yes.
Now we have this problem. Can't we reconsider continuing with the work in other ways, i.e., through select committees? I assume there's a select committee on health in Parliament. Then you could say to members, look, members, this is how you are going to do it. There are masks, there are sanitizers, there's social distancing, but we still have this pressing work. Which is what, as I understand Miller, what the UK Supreme Court suggested was that even in that instance, when the PM prorogued Parliament, he didn't consider whether or not there were other ways. If you look at paragraph 60, paragraph 60,
Paragraph 60.
yeah, where it says, perhaps most tellingly of all, the memorandum does not address the competing interests of going into recess and prorogation. Shouldn't that have been the point, that
No.
that debate should be held with members, with Parliament, to say, well, what are the merits and demerits
If you,
of actually ensuring that we stem this fight? And I'm raising this issue because I'm going to suggest to you that, in fact, Parliament is not an irrelevant factor in the front line of fighting coronavirus. It should actually be there to ensure that it lends a hand in fighting coronavirus. It should not just be a matter for the executive. Because even the judiciary here, the Chief Justice, had to actually devise a plan. Maybe that we are sitting in this fashion precisely because the Chief Justice was consulted. Shouldn't that similar consultation have been made with Parliament to say, how are you now going to do your work? Or is it considered that parliamentary work is not an essential business?
no, Your Lordship, but I think let's address it in stages.
Yes,
and then I'll go
in
to
stages,
the,
please.
I'll go to the committees.
Yeah.
The first point I wanted to address was that the issue of utmost importance is that Parliament, if not prorogued, is entitled to meet as a whole.
Yes.
Now, it cannot be suggested that any other measure would be advancing the justification, the reason why the Prime Minister had decided that prorogation was necessary. In other words, it is one thing to say, well, maybe individual members could cooperate, as opposed to how does the institution itself function. The institution itself functions in the first place as a unit, but in certain circumstances only as committees. Now, but then the matter transcends. If we go to committees and the question of the collateral damage, the question then transcends and becomes one of how do you deal with situations of emergencies? Is it actually true in legal argument, in legal form, that the collateral damage will happen as it happens or would happen when there is no emergency? I submit not. I submit that in any event, it presupposes that an emergency, when in an emergency, you must apply the same rules that you apply in a non-emergency. And my submission is that it is not correct to say so. It is not. The same proposition that Your Lordship puts to me, for example, from the point of view of the regime created by the emergency, the regime created by necessity, is that committees could still proceed with their work. Committees, there will be no one. I can't imagine anyone in his right senses coming forward to say, this committee was wrong in continuing to do certain things. Yeah. But certainly, insofar as what is being proposed for, what is being argued for here in the papers, what is being asked for is not what His Lordship is talking about. What is being asked for is that we want to meet as a totality of Parliament to pass legislation. Now, my Lord, it is my submission that in any event, even that legislation, if you take the issue of necessity to its logical conclusion, it does not follow that the consequences, which are not mandated otherwise than by tradition and convention, would adhere or would inhere in respect of an emergency. It is my respectful submission that would not be correct.
But the effect of prorogation is that it decapitates the second arm of the state. It does decapitate, and there are issues about even the length of the prorogation itself. If it takes 3 months, when actually the lockdown is for 21 days, is it not really overboard? Couldn't
No,
they have said,
no.
well, we are going to prorogue Parliament for the duration of the lockdown, and when the lockdown goes, they like every other institution, they'll go back to business because, after all, they are transacting an important work.
No.
And when you talk about an emergency, I know none of the parties have raised that issue.
Yes.
Even an emergency declared by the Prime Minister is under parliamentary oversight, because ultimately it's Parliament which will have to decide the life of that emergency after 14 days.
After 14 days, that is correct. But the point that I'm trying to make, is that what is pleaded here
Yes.
is that Parliament convene in its totality, and it is my humble submission that even in respect of the Miller case, you will see that there are certain circumstances, even in the Miller case, where it is said some of the business is saved from collapse.
But when you say in its totality, Mr. Where is that pleaded?
No.
Are they saying you should meet in totality, or they are merely saying that Parliament should meet?
It should meet, and when it meets, it cannot meet as committees.
But isn't it suggested somewhere that at the time of prorogation, this Parliament was doing certain business?
No, the suggestion is
by way of committees.
Let me just be sure. But that is what
the Attorney General sits in Parliament. Maybe you can take instructions from him.
No, let me just
matter.
get the pleadings first, and then we'll do that. In any event, the point that I'm making, Your Lordship, is that.
Yes.
Oh.
Sorry, I know you had said you'd go for, you'd go until 1:30, Mr. Taylor. You think by 2 you'll be through?
I don't have to be through by 2 o'clock, my lord.
Yeah.
Maybe we should go and have something, and then we'll come back.
You won't be through by 2?
No, I won't be through by 2.
Okay. It's 1:45, is it?
Yes.
Can we come back at
2:30? 2:30.
Is 2:30 in order, or you want us 2:45?
2:30.
2:30?
Yes, 2:30.
Okay. The court will adjourn until 2:30.
Yes.
Because I was spending